Welcome to this event, and many thanks to you all for joining us. Well, almost exactly a year ago, on the 21st of November 2023, I left my previous job as the designated family judge here and joined these chambers as an associate member. I'd like to take this opportunity to express my profound thanks to them for the support and guidance that I have had over the past year. I'm sure that many others will have experienced the same from the array of truly dedicated barristers and clerks that make 3PB the chambers that it is, chambers that I'm now very proud to belong to. I still sit in the Court of Protection, as I have for some years. As such, I know the degree of specialism that this work requires and how dependent we are on those who practice in it to get a just and legally correct outcome for those who need protection. This area of work has its own statute, rules, case law, and indeed language. Today, we're going to hear from two exceptional practitioners in a particularly complex and important area of Court of Protection practice, cases involving serious medical treatment. We're going to hear first from Matthew Wyard. He is a Court of Protection and public law specialist. He represents individuals, local authorities, central government, health bodies, and deputies. He acts in health and welfare and property and affairs proceedings as part of his wider public law practice. He is the chair of the Court of Protection Practitioners Association in the West Midlands and has been ranked for many years in both Court of Protection and public law work within the leading directories. Then we're going to hear from Jim Hirschmann. He specialises in Court of Protection, education and social care law, together with related public law issues, helping clients to navigate the law and to resolve disputes when they arise. He acts for the full spectrum of parties involved, including patients, families, and public bodies. He is ranked as a rising star in the Legal 500 for Court of Protection health and welfare work. He is a Court of Protection Bar Association committee member. So thank you to Matthew and Jim. And I'm now going to hand over to Matthew for the first part of the presentation.
Thank you, Stephen, for that introduction. I'm sure Chambers is equally as happy and delighted that you've joined us as it sounds like you are to be here. So thank you for that introduction. There are 5 things that Jim and I are going to talk to you about today. So firstly, I'm going to start with a refresher on the very basics of medical treatment law before looking at 2 recent cases, the Leicestershire case and the Cardiff Vale case that you've got the reference for on your screen. Jim's then going to take you through NHS NW London ICB and AB and the Health Service Executive of Ireland and SM, which is an interesting case actually. It's going to be one that I'm personally looking forward to hearing about as well. But let's start by firstly looking at the basics of SMT work. Now it's wrapped up, in theory, at least in the jurisdiction of the health and welfare aspect of the Court of Protection, but really I think it's becoming a more of a standalone area, certainly with its own nuances. And we get the definition of serious medical treatment from Regulation 4 of what most of us know as the IMCA regulations, and that's treatment that involves providing, withdrawing or withholding treatment in circumstances where there's a fine balance between the benefits and burdens of that treatment, or if there's a choice of treatment where which treatment to pursue is finely balanced. The more developed definition comes from the NHS Trust and Why, the Supreme Court case from 2018, in which the Supreme Court considered when medical treatment cases should be issued in the court. And it found that where medical treatment decisions are finally balanced, or there's a difference of medical opinion, or frankly a lack of agreement on a proposed course of action, then the right thing to do would be to issue the case. Now, the decision of the NHS Trust and Why has been put into helpful guidance issued by Mr. Justice Hayden in 2020. And really, that looks at when medical treatment cases should be issued. And there are two fundamental points that it's important for practitioners to know. Number one is a reflection on Section 5 of the Mental Capacity Act 2005, which is where there is complete agreement as to a patient lacking capacity and for particular treatment being in a patient's best interests, then that treatment can be provided or withheld in accordance with an agreement reached between all the parties to a dispute. So in other words, if the doctor believes that P lacks capacity to make the decision about treatment, and the doctor believes that it's in P's best interests for a particular course of treatment to be pursued, all of the family members agree, and there's no dispute, then, at least in theory, Section 5 of the Mental Capacity Act can absolve the clinicians of any adverse consequences if they pursue that course of treatment. However, as we know, that's not the typical case where, following any clinical decision-making process, the way forward is finally balanced. Those words, again, have come from the IMCA regulations, and we see throughout the NHS 2018 Supreme Court decision. Or where there's a difference of medical opinion or lack of agreement, then the matter should come to court and it should be considered. Where that relates to life-sustaining treatment, then it must be brought to court. Now, alongside understanding what medical treatment proceedings are and when proceedings should be issued, there are, in my view, 5 key procedural differences that practitioners need to know. Number one, something that will be fairly common to most health and welfare practitioners is P being a party to the proceedings. Anyone on the call who practices in the property and affairs jurisdiction, that will be slightly unfamiliar territory. It's not usual in those kind of proceedings for P to be joined as a party. But in medical treatment decisions, P is always a party. Now, as with anything in law, that is caveated with one exception, which is in cases of exceptional urgency that I'm taking to be overnight proceedings being issued or proceedings issued at the weekend by an NHS trust. P won't be a party, at least for the first hearing, because the official solicitor doesn't have an out-of-hours service. So in effect, what happens is you'll have the NHS trust or ICB, whoever's issuing the application urgently, having the first hearing done on an ex parte basis, then to be restored often the next day once the official solicitor has been brought on board. That takes me to point 2, which is this. The official solicitor in medical treatment cases litigates those disputes themselves in-house. So if you're a health and welfare solicitor thinking, well, are we going to get into these proceedings in this area of work and start representing P? No, you're not. Thirdly, importantly, the cost rules are slightly different. It's not reflected in the COP rules themselves, but the general practice is that the NHS Trust pays 50% of the official solicitor's costs in proceedings. And we'll come on when we look at the Cardiff and Vale case to look at where that can be changed. Point number 4, which makes a fundamental difference to anticipated timescales of this litigation, is that unlike health and welfare proceedings where often capacity as an issue can be agreed, in medical treatment cases, the official solicitor will nearly always want to get its own independent capacity evidence. And lastly, if you're representing the trust, anonymity is not always guaranteed, particularly where it's a large trust with multiple locations. So that's the definition of medical treatment cases and the procedural basics. There are 3 important legal principles that the audience need to be aware of for the remainder of this talk. Number one is why these cases are necessary at all, and that's because a doctor cannot treat someone without their consent. Anyone who's ever had an operation will be horribly familiar with the feeling of sitting in a hospital bed with your medical team asking you to sign the treatment consent form. If you don't consent to medical treatment, it's a trespass. And that can be giving rise to tortious damages. The second principle is one that will be familiar to those working in the Court of Protection. It's that, as with any other health and welfare case, the court can only look at the available options. And in AVS and in NHS Trust, the Court of Appeal confirmed that the court can't order medical treatment to be carried out if the treating physician or clinician is not prepared to carry it out for clinical reasons. And in Aintree and the University Hospitals NHS Foundation Trust in James, it was confirmed that an incapacitated patient's views have no more importance than a capacious patient's views, i.e. the fact that they are incapacious does not mean that they can overrule the clinician in a way that a capacious person couldn't either. And the third key point is how these cases are made up legally. By that I mean, what kind of order are you seeking? Well, in the case of a medical treatment case, it's not in fact an order at all, it's a declaration under Section 15 of the Mental Capacity Act. The key question for the court in that situation is whether it's lawful to give treatment to a patient. So what you will typically do is issue a case seeking a declaration that the treatment plan you are putting forward, i.e. your proposal for treatment, is lawful to give. Now, with those basics in mind, let's turn to consider the first of the two cases we're looking at today. So case number one, Leicestershire County Council and P, NHS Leicester, Leicestershire and Rutland Integrated Care Board. Now, for context, this is not in fact a medical treatment case. The importance of it is that it looked at the making of anticipatory declarations. So bearing in mind what we've just looked at and how you issue SMT proceedings and the COP and what you're looking for, it's important for that fact. The facts of the case then were as follows. P was a female suffering from dissociative identity disorder. Some people will be more familiar with that under its old name, multiple personality disorder. For the film buffs in the room who've seen the film Split, that is the rather problematic diagnosis that the protagonist in that film has. It's a controversial diagnosis, although it's in the DSM-5. There's a lot of medical debate about whether it's a legitimate, distinct disorder or not. And that we saw firsthand in this case, because one of the capacity assessors' evidence was that whilst they accepted the symptoms that P demonstrated, they didn't accept that she had DID. Rather, they took the view that she had complex PTSD with dissociative characteristics. What did the case concern? Well, it concerned whether P had capacity to make decisions about her care and contact with others. The evidence was that she was being sexually abused. She would leave her place of residence to be abused, and therefore the local authority in this case was seeking declarations and orders in relation to whether she had capacity to have contact with particular people. Now, at the end of the evidence that was heard, all parties agreed that when P did not disassociate, she had capacity. The evidence in relation to her disassociation was that she often coped by taking herself to her bedroom and isolating herself. So in reality, there was often situations where whilst she was disassociating and lacked capacity, there wasn't in fact any harm or risk of harm to her. Because of that, there were then two competing positions before the court. The local authority's view was that the court should make an anticipatory declaration that when P disassociates, she lacks capacity, and in that situation, best interests decisions could be made on her behalf about who she had contact with. On the other hand, the other position was that she was ultimately, regardless of whether she was disassociating and when she lacked capacity, she was unlikely to make decisions when she was doing that, because she, on the evidence, would take herself to her bedroom and not engage. So it was relatively rare where P may put herself at risk of harm. And in those circumstances, in any event, there were safeguards under Section 5 of the Act that would prevent her from having contact with the people that they were trying to prevent her from having contact with. What did the court do? Well, having set out the background facts and the evidence, it considered the two approaches to fluctuating capacity that are regularly considered by the court, whether or not to make anticipatory declarations or whether to take a longitudinal approach. And in this case, on the basis that most of the time P had capacity to make decisions about care and contact with others, but it was only on a rare occasion that she didn't, it decided to make anticipatory declarations. And what's interesting in this case, because it was raised again, the court has confirmed entirely now, I think it's entirely settled off the back of this case, that there is jurisdiction under Section 15 of the Mental Capacity Act that enables the court in principle to make anticipatory declarations. And you can see from the quote coming from the case on the slide, the specific reasoning of the court here relates to the specific language used in Section 15C of the Act. And there's reference to actions yet to be done, which is, as the court explained in this case, an obvious reference to future acts, and therefore anticipatory declarations must be able to be made. One of the interesting arguments put before the court was on behalf of the local authority, which was whether or not you needed a declaration of incapacity at the time that the anticipatory declaration was made. And you can see from the quote on the slide, the court dismissed that in its entirety. So in other words, the court has confirmed that it can make an anticipatory declaration that a future act will be lawful, and P does not have to lack capacity at the point that decision is made in order to be able to make an anticipatory declaration. That is, in my view at least, helpful for NHS trusts when they're considering future actions. Now, the court did give some weight to the longitudinal view, and it did consider the other options available to it. And in making the anticipatory declaration, it outlined various factors that the court should consider carefully when making an anticipatory declaration. They're broadly the 3 points on the slide. So whether, rather than granting the declaration, there is another way to manage the situation. So, for instance, Section 5 of the MCA being utilised. Secondly, the fact that there is a need to guard against any suggestion that P's autonomy and ability to make unwise decisions is being put at risk. So that's the paternalistic view that is looked at a lot in cases before the COP, how far the court should go. And lastly, the court should carefully consider the declaration being sought on its specific terms and the evidence, and whether that establishes with sufficient clarity the circumstances in which P may lack capacity and what to need to be done in order to implement the best interests decision. So in relation to the last two, my view is really number 2 is put to bed by number 3. In other words, as long as the anticipatory declaration being sought is extremely clear, the evidence base underlying the lack of capacity and the reason for the best interest decision being made is clear, then in theory, that will guard against the suggestion that P's autonomy and ability to make unwise decisions is being put at risk, because there will be a clear evidential basis for the court to be able to find that P is not simply making unwise decisions, rather they lack capacity at the relevant time. So in summary, Leicestershire County Council is a helpful authority. It confirms conclusively that an anticipatory declaration can be made and reminds us of the key points to consider when doing so. Now, with that in mind, let's turn to consider a case about pregnancy. Now, the Cardiff Vale University Health Board and NN, I think, is an interesting case to consider alongside the Leicestershire one, because there is an interplay with the question of an anticipatory declaration, because effectively what was sought in this case was an anticipatory declaration, although it wasn't couched in those terms. And there are, as you'll see as we go through it, three key takeaways from this case. One, whenever you're applying to the court, be clear about what you're asking for. Two, make sure if you are an NHS trust, a health board, or an ICB that you act promptly when you need to. And consider at the point you're drafting your application the specific declaration or order that you need, because if you don't, as we'll see in this case, things can go slightly wrong. So what were the facts of this case? Well, it concerned a lady called NN. She was a 32-year-old lady. She had a history of substance abuse and a long-standing diagnosis of schizophrenia. And she, when you read the judgment, had been detained repeatedly over the years under the Mental Health Act. Her most recent admission was in May 2024, so really not that long ago. She, as with any patient who's being detained, was subjected to various tests at the point of entry, including a urine test in this case, and she was found to have taken cocaine, amongst other things, and also to be pregnant. This was obviously told to P in the case, and she was initially happy that she was pregnant in May, although a few weeks later, by the 8th of June 2024, had changed her mind and was of the view that she wanted to terminate her pregnancy. Bearing in mind at this point, she was still detained under the Mental Capacity Act. Now, 13 days later, on the 21st of June, and the reason for giving you the specific date will become clear later, 13 days later, a professionals meeting was held at which this issue was considered, and it was decided that an application to the Court of Protection was likely because P kept changing her view as to whether or not she wanted her pregnancy to be terminated. And it was recorded in the minutes of that meeting on the 21st of June that the Health Board's legal team should be notified of the potential need to make a COP application. Over a month then passed, and bearing in mind, as you'll have heard from the second talk in this series, the one that I gave with Dr. Taylor about obstetric treatment, delay in obstetric cases is a real issue. Here, another month went by, and in mid-July 2024, P attended a pregnancy advice service clinic and again engaged in a discussion about terminating her pregnancy. It took another 3 days before another professionals meeting was held. So we've gone from the 21st of June to the 19th of July. That's nearly a month, which is a long time in the course of a pregnancy. And there was another professionals meeting. Again, at that point, no representative of legal attended. And again, the professionals in the meeting recorded that NN lacked capacity to make decisions about birthing, and that a COP application was likely to be required. Another 2 weeks passed, and on the 30th of July, another professionals meeting was held. This time a best interests decision was taken, although again, no lawyer was present. Now, by the 30th of July, P had been pregnant for 15 weeks and 4 days, so it was recorded clearly in the best interests meeting minutes that an application to the court needed to be made, and needed to be made fairly swiftly. Notwithstanding that, it then took another nearly 3 weeks for the application to be issued. It was issued on the 16th of August 2024. So this issue arose in May 2024. By the 8th of June, P was saying she wanted a termination. It was clear by the 30th of July that that is a matter that was going to be needed to be put before the court, if not earlier, than the 30th of July. And the application was still not issued until the 16th of August. And when that application was issued, the Health Board sought an order declaring it lawful and in NN's best interests to be offered a termination, and that in the event she chose to go ahead with that termination, the proposed treatment plan was lawful and in her best interests. So if you think back to what we touched on right at the start of this talk about how a health board should issue an application, or the fact that they are supposed to be asking for declaratory relief, you can start to see why the court might have some concerns about how this application was being litigated. The first piece of analysis that was undertaken, as with any termination case, was whether a termination would be lawful under the Abortion Act. In this case, it was. And the court then turned to consider the question of capacity. Now, as I touched on at the start, any case involving medical treatment, the official solicitor represented NN, and they sought independent capacity evidence. So there were two capacity assessments before the court, one from the trust, one from the independent expert. Both agreed that P lacked capacity to make the relevant decision. And we can see here from the extract on the slide the court's findings. So P had a limited understanding of what a medical termination would be for. She wasn't able to take on board and weigh up the pertinent negative aspects of the procedure or the impacts on her mental health. She had an inability and unwillingness to discuss the information relevant to the decision in any detail, and that wasn't just because of the personal nature of the decision. It was on balance of probabilities due to her difficulties in being able to consistently retain the news information that she'd been given as a result of her mental disorder. So at the point the decision was taken, the court found that P lacked capacity to make the decision. And then interestingly, later, it's entirely possible that at times during the medical termination procedure, NN would not be able to bring to mind or use information given by professionals as a result of her mental disorder. And so the court was satisfied that there was a real prospect that NN might lack capacity at a future point. So we can see there the relevance to the anticipatory declaration question when the court was considering the question of capacity. Issue 3 then was whether the court should approve the treatment plan. Now here, criticism was attracted from the court because of how the Health Board pleaded its case. It then changed its position at the hearing when it, I suspect, had been advised by its counsel it had strayed from the path. And what in fact happened in this case was a new treatment plan was filed, and the court's authorisation was only sought in respect of the elements of that treatment plan that amounted to a deprivation of P's liberty. And what the Health Board wanted to do was to offer P a termination. Assuming P said yes, that termination would then take place. And it was only once treatment had started, if it got to the point that P tried to leave the hospital once treatment had started, they wanted to have authority to restrain and sedate her to ensure that no further harm came to her and the treatment could be continued. So the court was not too happy about the way the application had been issued. Neither was the official solicitor, because as a direct result of that, the official solicitor sought, rather than the usual 50% of its costs, 100% of its costs from the Health Board. And that was on the basis that it had delayed unreasonably in issuing proceedings, and that delay had a prejudicial effect on NN. The Health Board, to its credit, accepted that there was a delay, but gave its reasons that was twofold. Firstly, the official solicitor wanted further capacity evidence, and that because of an issue in the hospital P was in at the time, an infection control measure had prevented access to her for a period. Now, the court looked at the various competing arguments and found that Cardiff and Vale had unreasonably delayed in issuing proceedings. The court determined that the legal team should have been involved from the 21st of June. So remembering from the chronology that was the first professionals meeting that was held after P said that she wanted a termination, and the meeting in which it was identified that an application to the COP was likely. Had lawyers been present from that first meeting, the court considered that they could have advised the clinicians earlier on the evidence required for a court application, and could also have focused the clinician's mind on what the court had to decide. Now, one question that crops up a lot, particularly in obstetric cases, is, well, when do we issue? Because we've known that P is pregnant for some time, but actually there's not necessarily a developing issue until the point of labour. The court considered that and pointed out that it was always possible, particularly in this case where NN's views changed, that an application once issued might need to be withdrawn and that the health board would have incurred costs unnecessarily. But given the importance and the particular speed required, given the statutory deadline for when the abortion could have taken place, the health board should have erred on the side of caution and issued an application sooner rather than later and taken the hit itself on costs if needed. The other issue taken into account was the detriment or the prejudice to P and her mother, and the court held that there was a serious negative impact on NN because of the delay and also on P's mother. And that was because P's mother was traumatized by having to see her daughter continue a pregnancy into its second trimester that she wanted terminated, and then had to support her through a late termination that resulted, unfortunately, in this case, in a baby being born alive. There's no mention in the judgment of what happened to the child. And then lastly, a final observation was made by the court reminding practitioners that it's incumbent on those concerned with obstetric cases to give careful scrutiny at the earliest possible stage to what orders and whether orders were required from the court, because in this case there was a mistaken belief that any best interests decision about termination of a pregnancy required court authorization, and as the court points out on there, that is not in fact the case, bearing in mind the ability to resolve yourself from liability under Section 5 of the Mental Capacity Act. So that's everything from me. I'm going to hand over to Jim, who's going to talk to you about the last two cases.
Could I mention before, Jim, you start, that there will be a question and answer session. If you could put any questions you do have on the Q&A function, please, and also the slides that the PowerPoint display that you're watching will be available to those who have attended after the event's closed. Thanks. Over to you, Jim.
Thank you very much, Stephen, and good afternoon to everyone. So I'm going to take you through two cases, starting with NHS North West London ICB and AB and others. Now, that's a judgment by Mrs. Justice Tice that came out in October of this year. Now, the principal issue in that case was whether it was in AB's best interests for continuation of clinically assisted nutrition and hydration. The clinical view was that that is not in AB's best interests, and some, but not all, of the family disagreed. Now, the court noted, and Matthew's covered this already, insofar as what the arrangement should be, the applicant happily had those arrangements in place, which provided where there is no agreement or the decision is finally balanced, an application should be made to the Court of Protection to be determined. But as we will go on to see, delay was also an interesting feature of this case. So who was AB? She was a lively and energetic and much loved mother to 3 children. She had a wide circle of friends and close friends. But on the 30th of March 2015, she tragically suffered a subarachnoid hemorrhage secondary to a right cerebral artery aneurysm during an exercise class. Following treatment, she was discharged into the specialist nursing home within the Royal Hospital for Neurodisability, and she had been there since, so 9 years. The medical evidence was that AB is minimally conscious and on the lower end of that, and that was in keeping with the then relevant but since updated national guidelines following onset of brain injury. AB was dependent upon clinically assisted nutrition and hydration and entirely independent on others for all aspects of her care. It was said if she experienced anything in the last 9 years, it was likely distress. It was highly unlikely that her condition would change. And over the last 3 years, AB had been treated for about 20 infections, including COVID-19, skin infections, and urinary tract infections. At paragraph 21 of the judgment, you'll see a whole list of the high level of care that AB required. AB was described as grimacing and displaying pain behaviour whilst undergoing moving and handling, which I think had to happen every 4 hours. She was regularly repositioned, moved and handled to avoid the formation of ulcers and to maintain skin integrity. There was recognition at paragraph 26 that she smiles, but Dr. D's conclusions were that those were involuntary movements without any meaning extracted from stimuli applied or any communication intent behind their facade. AB's life expectancy with continued treatment was likely to be less than 3 to 4 years. If clinically assisted nutritional hydration ceased, it would be 1 to 3 weeks. Now, a key feature in this judgment was delay and RNH and the way that it had been dealing with cases. For AB, the formal best interest review was not started until early 2023. That was 7.5 years after her initial admission. And the reason for that was a systemic failure in the RNH to have the relevant framework in place for making these best interests decisions in a timely way. They had been criticised of that in 2021, and you'll see the reference for the judgment there. Following that judgment, they had had an internal review of the legal framework and the wider landscape, which was now said to be pellucidly clear within the RNH. There was now a requirement for regularly structured reviews of a person who is in a has prolonged disorder of consciousness, PDOC, with an intense focus on their individual ongoing needs and timely best interests decisions being made. And the emphasis is that at each stage, those decisions need to consider whether treatment which may have enhanced the patient's quality of life or provided some relief from pain originally has now gradually or indeed suddenly reached a pivoting point where it becomes futile, burdensome and inconsistent with human dignity to continue the treatment. And the obligation was said by Mr. Justice Hayden to be vigilant to such an alteration in the balance. Now, the court noted at paragraph 60 to 63 that RNH is a charity. Most of the patients placed there were NHS funded, but RNH was thought to have one of the largest cohorts of patients in PDOC in the country. And it was noted that they had moved from a situation pre-21 where they would continue clinically assisted nutrition and hydration unless concerns were raised, to one now where they would more proactively consider whether continuation of that treatment is in a patient's best interests. So at paragraph 64, you can see their updated process. There was a 3-stage process that they had now adopted. First of all, there would be a best interest decision with consultation with those close to the patient by the decision maker and the multi-professional team. A second opinion from an independent expert would confirm that there's a prolonged disorder of consciousness. And 3, there's an assurance process that the requirement of the process have been met. There was a programme of training and education rolled out to staff, and there was agreement of a new protocol about how most productively to work with the ICBs regarding timeframes and responsibilities for various actions to ensure that applications to the Court of Protection are made in a timely way. At paragraph 64, the judgment made clear that within RNH, once a decision has been made to discontinue clinically assisted nutrition and hydration, or if a decision needs to be referred to the Court of Protection as there is disagreement as to what is in the patient's best interests, or it is finally balanced, then the case will be discussed at the weekly executive management team meetings. If they are satisfied that the correct processes have been followed, the matter is then referred to the Ethics Committee. And you can see that that had resulted in some substantive action. Paragraph 71, you can see how this change had played out since 2022. So Dr. Lottrell reported that since October 22, there had been 70 patients with the continuing care service at the RNH who had a diagnosis of PDOC and were receiving CAN. Consultation in accordance with the new policy had been completed for 51 patients. Decisions in relation to 7 had been referred to the ICB with a view to an application for court protection, and the process was ongoing in respect to 17 patients. 2 patients had died before the best interest consultation process concluded. And for patients who were newly admitted to the RNH, consultation of best interest decision for any incoming patients in PDOC would commence within 2 weeks of admission. So a much improved process for new patients. The situation of AB should not therefore be able to happen again. In terms of the judgment, the law was agreed and set out in paragraphs 36 to 49, and the court's best interest analysis is contained at paragraph 74 to 86. The court ultimately concluded that it was in AB's best interests in the wider sense for the clinically assisted nutrition and hydration to be withdrawn, as to continue to provide it was not in AB's best interests due to the very significant and increasing burdens her condition and treatment involved, and that outweighed the presumption of maintaining life. So just a few reflections of that case, and I think this dovetails with the second case that Matthew outlined. There seems to be a lacking appreciation in some areas of when to make an application to the Court of Protection. It's important to have the processes, and it seems that some elements of the health profession do not have those procedures in place. I think it's a good example of how the courts can encourage compliance with the law on a systemic level. The nudging from the 2021 judgment repeated in 2024 really does give a public review of the processes by RNH, and through talks like this and otherwise and advice by solicitors to their clients, one would hope that that would achieve more systemic change nationally. I think the case is also an illustration of just how vulnerable those without capacity are. For no decision to be made for 7.5 years in that case, made for distressing reading on my part. The second case I want to look at is the Health Service Executive of Ireland and SM. That's a judgment by Mr. Justice Hayden. Now, this case concerns a 24-year-old Irish citizen with a diagnosis of anorexia nervosa complex PTSD, mixed depressive and anxiety disorder. More recently, she had developed what was termed pervasive arousal syndrome with withdrawal syndrome. And an earlier judgment concerning her was reported in 2020, and you have the reference there. Now, what the Health Executive of Ireland sought in that case was recognition and enforcement of an Irish High Court judgment, which provided for the continued detention of SM at Ellenmead for the purposes of assessment and treatment. So what did the judge make of the position? What do you do when you have a judgment from another country and enforcement is sought in the UK? He set out the law and his analysis at paragraphs 13 to 44. And he reminded himself of Section 64 of Schedule 3 of the Mental Capacity Act 2005, which has given effect to the central provisions of the 2000 Hague Convention on the International Protection of Adults. And it's done so on a very wide basis. And it's Schedule 3 that makes provision for the recognition, enforcement and implementation of protective measures imposed by a foreign court, regardless of whether that court is located in a convention country. So the first thing that Mr. Justice Hayden did that I think is of particular note is referred to Mr. Justice Baker, as he then was, and what he said about Schedule 3 and the way it operates. And I've put 2 sections of that judgment in bold here. So first, what does Schedule 3 do? Well, Parliament authorised a system of recognition and enforcement of foreign orders, notwithstanding the fact that the approach of the foreign courts and laws to these issues may be different to that of the domestic court. And differences may extend not only jurisprudence and capacity. Thus, the fact that there are provisions within the Act that appear to conflict with the laws and procedures of the foreign state should not by itself lead to a refusal to recognise or enforce the foreign order. The safeguard there, the gate, if you like, that prevents unsound decisions making their way into English courts and being recognised by the English courts, is found by the court being able to refuse recognition on the basis that the foreign measure would be manifestly contrary to public policy. And that's a discretionary ground to refuse recognition. He reminded himself that the test is stringent and the bar is high. So what's interesting there is the recognition that differences may be extensive. It's not difficult to contemplate where they might arise. So a conflict of law, procedure, and even philosophy of approach does not in of itself require a domestic court to refuse to recognise or enforce a foreign order, which is surprising, or might be thought by some to be surprising. And I just wanted to illustrate an example of the way it's surprising. And this was the earlier judgment by Mr. Justice Hayden in 2020. And Mr. Setright, one of the barristers acting in that case, properly pointed out that the consequence of Schedule 3 might be that a court finds itself in the position of recognising enforcing orders of a foreign court, which would have the consequence of depriving P of his or her liberty in circumstances where this would not be possible under the domestic jurisdiction under the aegis of the Mental Capacity Act. And that might arise, for example, where the Court of Protection are being asked to recognise and enforce an order when an individual is being treated or is treatable under the Mental Health Act 1983. But the check is provided by the discretion to refuse enforcement where the order would be manifestly contrary to public policy. So what did the court make of the circumstances it was confronted with? At paragraph 36, Mr. Justice Hayden reminds us how serious a prognosis of anorexia nervosa is. It has morbidity rates that range from 10 to 20%, with only 50% of patients making a complete recovery. Of the remaining 50%, 20% remain emaciated and 25% remain thin. It was clear that that is what the Irish court was trying to avoid. It was trying to make sure that SM would get the treatment that she needs. And the order of the Irish court was very restrictive. And you can see it set out in the indented paragraph. To take all necessary or incidental steps, and to use such reasonable force and or restraint as may be necessary in so doing to promote and or ensure the care, protection, safety and welfare circumstances of SM, including providing her with hydration, sustenance, medication and treatment. And that included nasogastric feeding. Now, Mr. Justice Hayden grappled with the capacity evidence in that case. He considered that he needed to satisfy himself that SM continued to lack capacity. And he noted that the Health Executive of Ireland had agreed to instruct a psychiatrist to assess SM's current capacity relating to her treatment. He had no concerns about the best interest determination. However, he felt to make sure it was not manifestly contrary to English policy, that he would need to make sure that she continues to lack capacity in the sphere of decision taking around her medical treatment. And he regarded that as his obligation under the Human Rights Act and ensuring that the order remains compatible with public policy in England and Wales. So what he did was directed for further evidence to be sought from a capacity perspective, and then the case would return to him for further decision. So just 3 reflections on that case. The first is how hard it is to treat anorexia, and I think it's an example of an area where medicine perhaps has potential to further improve. It's an illustration of how international law is implemented domestically, and how, whilst you have a very wide discretion under Schedule 3 to implement foreign orders in the UK, there seems to be a significant overlap where a court will take a pragmatic view and say, well, as a matter of public policy, at the very least, some of the safeguards in the Mental Capacity Act and through the Human Rights Act need to be double-checked before I can implement that order. Quite where the line is drawn, where, for example, one might recognise a foreign judgment where it contradicts some elements of the Mental Capacity Act, is a little bit unclear. And I'd be interested to see more test cases, seeing where that line can be drawn and if there can be greater certainty as to where it's drawn. But also it's an illustration of how proactive the court protection can be when it's seized of a case in making sure that it is actually a case where someone lacks capacity, that there is actual decisions being made on their best interest against.
Can I thank everybody for joining this seminar? I've found it incredibly helpful, and we'll turn to the PowerPoints that Jim and Matthew have prepared in the future for guidance. Those PowerPoints will be sent out, and I very much hope that you've enjoyed this seminar as much as I have. And many thanks once again to Jim and Matthew for sharing their expertise and specialism. So good afternoon.